And we'll proceed with the last case on the docket, Sonnenfeld versus Sonnenfeld. Okay.
I would like to reserve 3 minutes for rebuttal.
Okay.
May it please the Court, my name is Joan Stefanik Briggs of the law firm Adams Briggs & Briggs in Daytona Beach, and I represent the appellant Roger Sonnenfeld. This is a consolidation of 2 appeals, final judgment of dissolution of marriage, and a final judgment awarding attorney's fees. The parties in this case were married 15 years at the time of trial and had a 13-year-old son. Shortly after the marriage, the wife was diagnosed with cancer, which did reoccur, and at the time of trial, she was in remission. One of the issues in this case involved the trial court failing to consider the tax consequences of awarding the husband.
Let me ask you about that, because I'm having some difficulty with that particular issue, and the difficulty stems from the evidence or lack of evidence in the record that the money in the account was going to be withdrawn, and the retirement account was going to be withdrawn to subject your client to the penalty in the first place. And I believe that at first he testified that the money would not be withdrawn, and then the testimony sort of changed and indicated, well, he would leave his options open. But I don't know that there's any evidence in the record that he was going to definitely withdraw it or that it had been withdrawn. And so help me with
even
the
though there
lack
was
of
no
evidence.
evidence in the record that he was going to, he didn't know what he was going to do.
Right. It seems that was his last bit of testimony.
But this court has held in Miller that when one awards, equity distributes marital assets, that you need to consider the consequences of income tax law on the distribution of those awards.
Well, the penalty would be different from tax consequences.
We're talking about a penalty here, a penalty for early withdrawing the funds.
That is,
and so that's, where's the evidence that was going to happen and that penalty was going to be incurred, other than your client's testimony that he would leave his options open?
there is no evidence that there was. He didn't know what he was going to do. Therefore, the court.
So what is the trial court supposed to do with that type of speculation and not knowing whether the penalty is going to be incurred or not? How can he give the tax credit for that?
That doesn't excuse the court from taking into consideration, and this court also in Vaccaro stated that one person shouldn't be given a marital asset that's going to be burdened with a tax consequence, because they get an unfair advantage of
but
one.
The only way this penalty can be incurred is if there's early withdrawal. Is that correct?
That is correct.
Okay, and so there has to be, it seems to me, there has to be some evidence in the record, and I think the third district in the Levon case basically said that it can't be based on speculation. There has to be some evidence in the record that the liability or the penalty is going to be incurred, and I don't see that in this case.
Well, it's the husband's position that he didn't know what he was going to do based on the outcome of this trial. Therefore, the trial court should have taken it into consideration under both Vaccaro and Miller. Furthermore, the trial court, when awarding the wife the former marital residence, which she valued at $183,000, and gave the balance of it to the wife as lump sum alimony. And it's the husband's position that the trial court erred as a matter of law in awarding both lump sum alimony and permanent periodic alimony to the wife when there was more than enough money in permanent periodic alimony to meet her needs. She testified at trial, substantial competent evidence, Social Security disability, she received $701 a month. Also, she received $334 for the son, total of $1035 she was receiving from Social Security. She testified that her expenses were $2297 and that she had a deficit of $1,600. However, she inaccurately listed the health insurance costs post-dissolution at $300 per month. There was trial testimony, both by the husband and by the wife, that...
But as far as the marital home is concerned, wasn't she given custody of the child?
That is correct.
The child needs a place to stay. Isn't that a factor that the trial court should consider?
Correct, but one can't determine, based on the fact that the court didn't consider the tax consequences, how much they were distributing to the wife as lump sum alimony versus equitable distribution.
Let me ask you about the term lump sum alimony, because more often than not it's misused. Alimony is really a support, whereas oftentimes you can have unequal equitable distribution, and the difference in the equitable distribution sometimes is referred to as lump sum alimony, even though it's really not support. It's just for whatever reason the judge has decided not to go 50-50. Is your position here that the difference in what the wife received versus 50% of what, she received 50%, whether that's support or is that unequal distribution of property?
She received it as lump sum alimony. If you look at the
but what does that
final
mean?
judgment,
That's what I'm saying.
it's based on,
Are you saying that's a support element or an unequal equitable distribution?
I'm saying here in this case, the judge awarded it as lump sum alimony, not as equitable distribution. And this is based on his findings in the final judgment. And he says, the court will make that award, meaning the marital home, both as equitable distribution of assets and the balance as lump sum alimony. Then the court went on to say, regarding the retirement account, that the court finds the equitable distribution requirement of the court must be taken into account. The court will do the same with the retirement account and value that asset for equitable distribution purposes at $149,000. So based on what's in this final judgment, he was awarding it as lump sum alimony for alimony purposes, support purposes, not as equitable distribution. And this court has held in Ledford v. Ledford that lump sum awards, alimony awards for support, are not justified when a permanent periodic alimony award takes care of the wife's need. And if you look at what the evidence showed, and there was a table on page 30 of the initial brief, which indicated what her expenses were. Based on her testimony, the health insurance and her automobile gas expenses were added on. Based on her income from Social Security disability, her monthly deficit was only $1,109, yet the trial court awarded her $1,300. And besides that, it's the husband's position that this was enough to support the wife and meet her needs because there was no mortgage on the former marital residence. The husband had that expense. He had to go out and find other housing. He was paying child support to her, plus the child's health insurance. And so she had no need for this lump sum alimony. The better solution would have been to award her exclusive use. And this court did address that issue in Lynch v. Lynch, where it held that where the main marital asset, and that's the case here, the main marital asset in this case was their marital home, that it shouldn't be awarded as lump sum alimony when there's no special equities, it's jointly owned, there's no need to do this, that the result can better be achieved by making them tenants in common and awarding exclusive use to this wife rather than awarding the whole house to her.
He got all of the retirement account, didn't he? It was $149,000.
$149,000 without.
And she got. But your argument is that the trial court didn't take into account whatever tax penalty would be incurred if he early withdrew the money.
That is correct, and the fact that then they award her lump sum alimony when there was no need to do this.
All right. So your argument is that then that the retirement should have been split in two?
That is correct.
That even though her life expectancy was such that she would not receive any of that?
She could have withdrawn that, and the husband offered substantial competent evidence she wouldn't suffer the tax penalties he would based on her hardship, the fact that her life expectancy was.
Well, but is it unreasonable for the trial court to look at that and say, well, half the retirement's not going to do her a whole lot of good with her life expectancy?
Yes, the court can, but then again, the court needs to be looking at the fact that we are comparing apples and oranges here. There's real equity in that house, $183,000. There's not real equity in that retirement account of $149,000. There's also a lack of substantial competent evidence to support the trial court's award of attorney's fees to the wife when the wife was in a better financial position than the husband after the distribution of the marital assets, the lump sum alimony, the permanent periodic alimony, and child support. This court in Naugel held that the purpose of Section 61.16 of Florida statutes is to assure that each party in a dissolution case has a similar ability to secure competent counsel. Further, this court in Naugel held that the trial court abused its discretion when requiring the husband in that case to pay the wife's fees and costs.
What about the argument that because the child was living with her that perhaps it's not equal? And they raised that argument in their answer brief.
If you look at how much in the reply brief, what her income is versus the husband's income. She has gross income of $1035 for Social Security disability. She has alimony of $1,300. Subtract that from the husband. Do your deductions. She pays health insurance between $72 and $92. And then she has net monthly income of $22.21 versus the husband's $24.67. But then, after we get that, we have to take from the husband the $140 he has to pay for health insurance for the child, plus the child support of $434. What does he end up with? $18.93 versus her $26.55. There's no way that they have equal incomes at all. She has a house that's paid for. He's paying child support to support the child, paying the health insurance for the child. I mean, there isn't more that he could give to her.
Let me ask you this. They raised in response to your point on appeal about attorney's fees that there was no temporary alimony awarded. What length of time was there between the petition and the trial in this case?
It was at the most 2 years, from 2003 to 2005. However, if you read further on, you'll see during this whole time period, joint accounts were never closed. It was accessible to her. Joint credit cards were available. So there was no need for temporary support because she had monies available.
The joint accounts doesn't really mean, I mean, from what I can tell from the record, he got his $10,300 and she spent her $10,300 in support. So that joint accounts really doesn't respond to their argument. Did he pay for expenses of hers other than paying child support during that 2-year period?
They had their joint accounts, so yes, he did.
Well, now, the testimony was, what I gleaned from the record, is they each got $10,300. She used her $10,300 to a large degree to pay for support. So that's already out of her half. They'd already divided that $10,300. I'm asking you whether he paid anything toward her support during those 2 years other than child support.
No, but he didn't need to, number one, because the other side didn't think it was necessary to file for temporary support because she was receiving money from their joint accounts. There was no need for her because the joint accounts were never closed.
Well, now, what's happening there is she's using half of an account for her support, and he's using half of his account. He doesn't need to use it for support because he has an income.
That is not correct.
Well, how is that not correct?
The $10,300 in 2005, 2 years after this whole case began, he said to her, I'm going to take half the money out of here and pay my attorney. You take the other half and pay your attorney. She chose not to. She didn't need that money for support. There's no...
She using for support? Yeah.
She was using the joint checking account that was open. Anytime she wanted money, she goes to their joint checking account and gets money.
That's my question. So she was using money from his income?
Correct. Money from the joint account, money from the joint credit cards that he was paying.
All right, that was my
question. So there wasn't closed accounts.
So he was paying support for...
Correct. Through the joint accounts that were never closed, the joint credit cards that he paid.
All right, that was my question.
The court also, this court in Mauck, M-A-U-C-K, also held that attorney's fees should not be awarded unless there's evidence of excessive litigation costs, which should be supported by express fact-finding. In this case, there wasn't any excessive litigation. If you look at what their income is...
Do you know how much money the wife withdrew from the checking account that the husband was putting the money into, and in terms that you would call support, that she used between the time they were separated and the dissolution? Do you have a figure for that?
No, I don't have a figure, but you have competent counsel on both sides, and if money wasn't available, that temporary support would have been ordered or would have been taken place. There was no need for it because her needs were being met by the husband.
And that was because she was able to withdraw the money from this checking account.
Correct, exactly.
You don't know how much she withdrew.
No, I don't. But the evidence speaks for itself in the fact no temporary support order was ever asked for or by the other side.
Okay.
Also, the joint credit cards, he would pay those debts if she charged stuff on credit cards. So it's the wife's position, the husband's position that the court should reverse this on appeal.
Okay, you've got 4.5 minutes left. Do you want to reserve that? Okay.
Please, the court. Horace Smith, representing the former wife with the firm of Smith, Hood, and Perkins.
Mr. Smith, would you address the attorney's fee issue and explain the case law generally states that if the parties are put in an equal position or the wife is put in a better position than the husband or vice versa, that attorney's fees really aren't appropriate in those circumstances. And my question to you is, looking at this record and looking at the awards that were made by the trial court, why wouldn't it be appropriate for us to say that she was put in an equal position, maybe even a little bit better position than him, and that the award of attorney fees was improper?
Well, I agree. If you would put in an equal or better position, she should not get her attorney fees.
Okay, was she put in an equal or better position?
Well,
If you say no, why?
I say no, why? Because the problem is, for example, what I did, and counsel did a different way, but I've taken the gross income of each party, deducting from the husband the alimony.
You're looking at the net to each, right? You're looking, instead of at the gross, you're looking at the net and saying that she's not coming out equal that way. But I mean, if we look at what each is given in terms of, you know, what she got in terms of the house, what he got in terms of the retirement account, and we factor everything in together, it looks as though she came out about equal, maybe even a little bit better. You want to go further and say, well, we need to look at the net. These are her expenses, and these are his expenses, and this is what she needs to spend, and this is what he has left over.
Well, I think you have to separate the retirement accounts and houses from that equation. I'm not, and if you don't.
Okay, well, all right, just do that then and explain to me why she didn't come out equal or better.
Well, because the husband earns approximately a little over $3,800 a month, I believe it was. And the wife, he pays $1,300 alimony. Now, of course, when you deduct that from his, he's still ahead of her. Now, from her amount is added, number one, they add to that the disability insurance that, or disability policy she gets for behalf of the child. That's added to her income. Number two, they then add child support, which he pays to her. It's added to her income. They then subtract, even though it's already been done in the guidelines, the fact that he pays the $140 insurance, they then add that again as taken from his subtraction, even though it's already done. You look at the child support guidelines, her obligation of child support is higher than his. When they get to the bottom line, they're saying, okay, they're somewhat equal if you take all those figures and you deduct what they say are his taxes, which is somewhat problematic. They're almost equal, but they have added to her all of the child support, and they've added to her also her VA disability that she receives on behalf of the child. Yet they're not considering that there's a second person there.
Well, in Ms. Quigg's reply brief, she has a chart. Tell me if you agree or disagree, that if you take his gross income, then deduct his child support, the health insurance for the child, his alimony payment, and his taxes, that his net is around $1,900 a month after he meets all his obligations.
Right.
And then her net, with the second person living in the house, the child, is around $2,655. So you got one household, $1,900, one person, one household, $2,655. Of course, you know, there's a lot of expenses that cover two people as equally as they do one. So, my question is that accurate? I mean, does her client have around $1,900 a month net after he meets all his obligations, and does your client have around $2,655 after she pays her taxes, realizing she's got a second child?
It's accurate that she's a little bit higher, and I believe it's a little high on that. I'm not sure exactly what you're looking at, but I think
That's from her reply brief, and I'm just asking if you agree or disagree with what her numbers are.
I agree they're almost equal if you consider all of the child support and all of the income that she has. The answer is she's almost equal with him, maybe a little bit higher.
Well, hers is $2,655 versus $1,900. That's $755 difference. So that your client's net is $750 more, realizing you got a second. I'm just asking if that's accurate enough.
Pretty much so.
Then how do we justify the award of fees to her, if that's the case?
Well, and that's when you need to consider that she has an obligation for child support also, and the answer is yes. Her obligation for child support under the guidelines, which is attached to the record, is some $546. His obligation is $400, and that already includes the fact.
Yeah, but don't you factor in the fact that she got the house, and was there a mortgage, any payments that need to be made?
There's no mortgage on the house.
All right, so she got the house, and he's paying his share of child support. She got the house, and she's supposed to pay some too.
Correct.
In terms of child support.
Actually,
and wouldn't it be fair that because she got the house, maybe she should pay a little bit more?
Well, she is paying more.
I mean, why isn't that appropriate?
Well, I think the guidelines are appropriate. She is to pay for it.
All right, so the ultimate question is if she came out in an equal position, or maybe even a little bit better than the husband, how do we justify the award of attorney's fees to her?
Well, only the fact that she's now got a second party with her that she has to support, which is not being played into the. We haven't subtracted. When you consider their incomes, we haven't subtracted the needs for the child, and we've added to her the child's VA disability.
Refresh my memory. Was he ordered to pay half her fees or the entire amount? I don't remember.
I'm sorry.
Was he ordered to pay half of the fee, her fees, or the entire?
Half of the fees.
Half of her fees.
Not all. On the other argument, counsel, as far as the pension is concerned, wants to take into account that the husband, if he liquidated his pension, would have a penalty. This is not allowed under Boyette. Boyette says you do not take into account any penalty concerning the pension in any event. But even if that were to be considered, the case law also indicates that there needs to be some type of testimony other than just the spouse themselves saying what the net value of the pension is. I certainly recognize that pensions have or pre-tax and have a taxable value. I would urge courts not necessarily require CPAs in every particular case, and I try to stipulate we don't need them. But nevertheless, the law still is that you do not count penalties into the situation at most part. And there's no evidence in this case of what the husband testified that because of the penalty, his pension is going to be reduced. There's no indication that there's going to be a penalty or should be a penalty. The Supreme Court.
Did he testify the penalty was $10,000? Well, I mean, part of it is if he withdrew all the money, it was, there's a tax consequence because you haven't paid the tax yet. Now you have to pay it.
Sure. And
part of it's the penalty. Was there any evidence in the record of how much was penalty versus how much was?
There's no evidence in the record. I think we have general knowledge of what the penalty is, but there is no evidence in the record, and that's why I say I think.
He testified what the penalty would be, didn't he?
I'm sorry.
He testified what the penalty would be, didn't he?
I don't believe he did.
You don't think he did?
And
And you're saying that the Boyette basically holds that the trial court should never consider a tax penalty in a situation like this?
They should not consider a penalty just because there could be a penalty involved if there's no sale, no anticipation.
Yeah, but basically, I think, maybe correct me if I'm wrong, I have not read Boyette, at least in quite some time, and you're more familiar with the case than I am. Obviously, I'll go back and read it, but I thought that if there was testimony that was credible, the trial court believed in a situation such as this, where the money was going to have to be withdrawn early and a penalty was going to have to be incurred, the trial court could take that into consideration.
I think if that were the case, the answer is yes.
Okay, so your argument basically is that there's no hard and fast, it's not that there's a hard and fast rule that prevents the trial court from doing that, it's just that there wasn't any evidence in this case that was presented to the trial court to find as competent.
Primarily.
All right, okay.
And as far as the house is concerned, the general rule basically is, and the Supreme Court has indicated on many occasions, that it's best to equitably divide the parties' property and to try to end the division between them of having to come back and deal with each other in the future. That helps the healing, helps to get over the divorce. In this case, the judge went in more detail than we see most courts in determining all the standards that are necessary for the finding of alimony and the finding of the reason why the wife should be awarded here the interest in the home, not only as part of equitable distribution, but lump sum alimony, and outlined specifically that she's terminally ill. It's not the doctor said yes, she's in remission, but her chances are zilch. She's it's going to return, and that's going to finish her off.
Let me ask one more question about going back to attorney's fees again.
Yes.
To steer you off course, but you're requesting fees in this particular case, and my question to you is if, and I'm not saying how we're going to rule, I'm just saying if we decide that fees were not appropriate and to be awarded by the lower court because she was put in an equal or better position than the husband, would you therefore not be entitled to fees for the appeal?
On the appeal, I don't think I'm entitled to fees on the appeal.
Mr. Smith, let me ask, in your answer brief, in response to the argument on attorney's fees, you mentioned maybe that's in lieu of temporary alimony. Ms. Briggs has gotten up and said that her client gave your client access, in effect, a part of his paycheck through access to the checking account during the course of the litigation. Would you agree or disagree?
That's not entirely correct. Partially, she did have access to the checking account, but she testified that she had to go to the remaining funds that he left in the bank account in order to support herself.
Do you know how much she withdrew from that account to support herself?
I do not.
And so her basic argument is that because she had that money available to her, you didn't have a need to file for temporary support or request it. Is that right?
The record would not support another.
All right.
Thank you.
Okay, thank you.
I did want to correct on the child support the husband is paying, that 434 does not include the 140, and you'll see this on the child support worksheet that was offered as part of our appendixes, that because he's paying the 140, his support is only the 434, and that's one of the reasons there's a difference in what support each would owe, because he is paying that. And this accurately does reflect on page 13 what his income is versus what the wife's income is. Also, the trial court itself indicated and held that the parties had a relative equalization of income, yet still awarded attorney's fees. In regards to the tax consequences, yes, the husband did present evidence that there would be a 10% penalty. If you look at the trial record on page 251, he states, when asked, does the sheet, referring to an equitable distribution sheet,
Trial court didn't really think that was adequate evidence. Did the trial court? Basically, the trial court thought that was not adequate evidence to determine what the amount of if there was going to be a penalty, what the amount would be. Isn't that correct?
That's not correct, because the trial court made no findings whatsoever. I don't know what the trial court thought. There was substantial competent evidence offered by the husband during his deposition that this doesn't represent what the true value of this. On his financial affidavit, footnote 12 says, you know, my pension plan is worth $89,000, not $149,000, if you want to compare it to an equity in a former marital residence. Also at trial, he testified to the fact he would suffer the 10% penalty. His wife wouldn't if she withdrew it. There was evidence given. Miller and the other cases from the Fifth doesn't say that it has to be expert testimony offered. And it's the husband's position that substantial competent evidence was given regarding the fact that this tax consequence should have been included, and we don't need expert testimony to do that.
Well, with regard to the 10% penalty, how is that different than someone saying, I may sell my house, and therefore deduct the commission? I mean, isn't the case law that there has to be something more definite than that I may do it? And that's, you know, his testimony, I believe, was twice that he wasn't planning on withdrawing it, and one time he might. He's keeping his options open. So how is that different from the cases that say if I want to sell my house, I should have the commission deducted when it's speculative?
Because on this, we know that we're comparing apples and oranges. We know for a fact that that equity is actually there in the house. She's not going to sell it. She has free housing. She's not going anywhere. The husband has that expense.
All right, but, on the penalty part, his testimony was he didn't know what he's going to do.
That is correct.
So how can the judge assume that he's going to sell it?
He still has to take into consideration that we are comparing two different items. We're comparing an item with a tax consequence. We're comparing it to something that has actual equity in it. Therefore, they're not equal. You can't make that equal when you're doing an equitable distribution.
There's two parts with regard to the pension. One is the fact that it's pre-tax dollars.
Correct.
And then there's a second part that's penalty.
Correct.
Now, the penalty, I don't see anything other than speculative testimony on your client's part. Now, the pre-tax, I understand. But as far as the penalty, you know, statement, I don't know what I'm going to do, I don't know how any trial judge could find that as a basis that they intend to withdraw from their pension.
I agree, but again, we're not comparing two like items when he equitably distributed, and that's why it should be reversed on appeal. And there was no need for that lump sum alimony when that permanent periodic alimony award more than met her needs. And you can look, based on our own trial testimony, on page 30, I went through what she said, what she put on her financial affidavit, and you can see.
Other than the potential penalty for early withdrawal, what other tax consequences are you referring to that the trial court should have considered but didn't?
The tax bracket that he would be in if he withdrew that money, and that's what he figured out. If he withdrew all that money.
But it all depends on if he withdraws the money. Are there any tax consequences that you're referring to that you argue below that are not dependent on whether he withdraws the money or not?
No, but it's still the husband's position that the trial court should be reversed on appeal.
Okay, thank you both very much. Your time is exhausted. Well argued on both sides. This concludes the oral argument session for today.